Detention under Republic Act on 9372. Number 1. What is Republic Act on 9372? It is an act to secure the state and protect our people from terrorism. This act shall herefore there known as the Human Security Act of 2007. This law was amended by Republic Act on 11479, otherwise known as Anti-Terrorism Act of 2020. Number 2. Does the time for the delivery of detained person prescribed and Article 125 apply to suspect terrorists who are detained under Republic Act on 9372. A person charged with or suspect of the crime of terrorism of the crime of conspiracy to commit terrorism shall be delivered to the proper judicial authority within a period of 3 days count from the moment of said charge of suspect person has been apprehended or arrested, detained, and taken into custody by the said police or law enforcement personnel without the police or law enforcement personnel having said person in custody incurring any criminal liability for delay in the delivery of the detained person to the proper judicial authority. However, the arrest of a suspect must result from the surveillance under Section 7 and examination of bank deposit under Section 27 and Section 18 and RA number 9372. Ang taong dinimanda o suspensado sa krimen ng terorismo o sa krimen ng conspiracy to commit terrorism ay kailangan masampahan ng kaso sa loob ng 3 araw mula noong demanda o suspensadong tao ay nahuli, ikinulong at inilagay sa kulungan ng mga pulis o alagad ng batas na hindi maglalagay sa kanya sa pananagutang kriminal sa pag-antala ng pagsampa ng kaso sa korte. Subalit, ang paghuli ng mga suspek ay kinakailangan muna ng pamamatiyag sa ilalim ng Section 7 at pagsisiyasat ng mga deposito sa bangko sa ilalim ng Section 27 and Section 18 and RA 9372. Number 3. Under RA 9372, who must be notified before a suspect terrorist is detained. Before detain the person suspect of the crime of terrorism, the police law enforcement personnel concerned must be present him or her before the judge that letters residence or office nearest the place where the arrest took place at any time of the day or night. Bago ikulong ang taong suspensado sa krimen ng terorismo, ang mga pulis o alagad ng batas ay kailangan maipresenta siya sa kahit sino sa lugar na kung saan nakatira ang nahuli o ang opisina na pinakamalapit sa lugar kung saan nangyari ang paghuli sa kahit anong oras sa araw man o sa gabi. It shall be the duty of the judge, among other things, to ascertain identity of the police or law enforcement personnel and the persons or person they have arrested and present before him or her to require of them the reason why they have arrested and person and detained by questioning and personal observation whether or not and suspect has been subject to any physical, moral, and psychological torture by whom and why. The judge shall then submit a written report of that he or she had observed when the subject was brought before him to the proper court that the jurisdiction over the case of the person arrested. The report shall be submitted within 3 calendar days from the time the suspect brought to his or her residence or office. Isa sa mga tungkulin ng WES ay ang pagtino sa pagkakakilanglan ng mga pulis o alagad ng batas at ng tao man o mga tao na hinuli nila at iniharap sa kanya para matanong sa mga dahilanan kung bakit nila nahuli ang tao at alamin sa pamamagitan ng pagtanong at personal na obserbasyon kung ang suspect ay inilagay ba sa physical, moral at psychological na pagpapahirap sa kanino man at bakit. Ang WES ay dapat magbigay ng nakasulat na ulat sa kaniyang obserbasyon kung kailan ang suspect ay idinala sa kaniyang harap patungkol sa kaso ng pagdakip ng tao. Ang ulat ay dapat ibigay sa loob ng 3 araw sa kalendar mula nung ang suspect ay dinala sa kaniyang tirahan o opisina. Immediately after taking custody of a person charged with or the suspect of a crime of terrorism or conspiracy to commit terrorism, the police law enforcement personnel shall notify and write the judge of the court nearest and the place of apprehension of arrest, provided that where the arrest is made during Thursdays, Sundays, holidays, or after office hour. The written notice shall be served at the residence of the judge nearest place where the accused was arrested. Kaagad-agad pagkatapos ng pagkakulong ng taong idinimanda o suspensado sa krimen ng terorismo o conspiracy to commit terrorism, ang mga pulis o alagad ng batas ay magpasabi sa pamamagitan ng pagsulat sa WES ng korte na pinakamalapit sa lugar na ginawa ang paghuli. Dapat na kung saan ang paghuli ay ginawa sa panahon ng Sabado, Linggo, kapistahan o pagkatapos ng oras ng opisina ng nakasulat abisado ay kailangan magbigay sa tirahan ng WES na pinakamalapit sa lugar kung saan ang akusado ay hinuli. The penalty of 10 years and 1 day to 12 years of imprisonment shall be imposed upon the police or law enforcement personnel how failed to notify the judge as provided into preceding paragraph and section 18. Ang parusa sa 10 taon at 1 araw hanggang 12 anyos na pagkakakulong ay ipataw sa mga pulis o alagad ng batas na bigong ipaalam sa WES ayon sa nakasaad sa naunang talata ng section 18. Number 4. What is the period of detention is the event of an actual or imminent terrorism attack. In the event of an actual or imminent terrorism attack, suspect may not be detained for more than 3 days without written approval of a municipal, city, provincial, or regional officials and a human rights commission or judge of the municipal regional trial court, the sangguniang bayan, or the justice of the court of appeals nearest the place of the arrest. Sa panahon ng aktwal o sa puntong pangyayari ng mga terorismong pag-atake, ang mga suspect ay hindi pwedeng makulong sa lagpas 3 araw na walang nakasulat sa pahintulot mula sa pang-munisipyo, pang-lungsod, pang-probinsya o rehiyon na opisyal ng Human Rights Commission or West ng munisipyo, regional trial court, sangguniang bayan o isang mahistrado ng Court of Appeals na pinakamalapit sa lugar na ginawa ang paghuli. If the arrest was made during Saturday, Sundays, holidays, or after office hours, the arresting police of a law enforcement personnel shall be bring the person thus arrested to the residence of any of the official mentioned above, that he nearest the place where the accused was arrested. Kung ang paghuli ay ginawa sa panahon ng Sabado, Linggo, kapistahan o pagkatapos ng pang-opisinang oras, ang panghuhuling pulis o alagad ng batas ay dapat dalhin niya ang paghinuli sa pamamagitan ng alinman sa mga opisina na ibanggit sa itaas na pinakamalapit sa lugar kung saan ang akusado ay nahuli. The approval of writing of any of said official shall be secured by the police of law enforcement personnel concerned within 5 days after the date of detention of the person concerned, provided, however, that within 3 days after the detention, suspect whose connection with the terror attack of threat is not established shall be released immediately. And Section 19, ang pahintulot ng nakasulat ng alinman sa mga nabanggit ng mga opisyal na kailangan maitago ng mga pulis o alagad ng batas na nauukol sa loob ng 5 araw pagkatapos ng petsa ng pagkakulong ng mga taong nauukol, subalit sa loob ng 3 araw pagkatapos ng pagkakulong ng suspect na ang kaugnay sa terorismong pag-atake o pananakot ay hindi napatunayan, kailangan siyang palayain agad. Number 5. What is the penalty of failure to deliver the suspect to the proper judicial authority within 3 days? The penalty of 10 years and 1 day to 12 years imprisonment shall be imposed upon any police or law enforcement personnel who has apprehended, to arrested, detained, and take into custody of a person charged with or suspect of the crime of terrorism or conspiracy to commit terrorism, and fails to deliver such a charge or suspect person to the proper judicial authority within the period of 3 days. And Section 20, ang parusa sa 10 taon at 1 araw hanggang 12 taon pagkakakulong ay dapat ipataw sa mga pulis o alagad ng batas na nahuli at nakulong sa taong dinimanda o suspetsado sa krimen ng terorismo o conspiracy to commit terrorism at naibigong magsampa ng kaso sa korte sa loob ng 3 araw.